Once the law is chosen, all questions relating to interpretation of contracts fall under it. So under the breach and performance and breach, the proper law outlines how obligations should be fulfilled and what constitutes a breach. For example, in Prodesport versus ED and F-Man Limited, even though Romanian law rendered further exports illegal, English law as the proper law determined the impact on contractual obligation. The law of the contract controls the parties' obligation and consequence of breach. The proper law specifies what each party must do, when and how. For instance, it fixes deadline, quality standard, and pricing obligations, whether an obligation has been breached, and how by and judged by the proper law standard. This also includes issues like excuse of non-performance. Such doctrines are part of the substantive law of the contract. For example, thus, if a seller fails to deliver on time, the proper law determines what remedies or defenses arise from that breach, e.g., whether time is of essence or what notice is required. So in our remedies, we have the damages specific performance. We said the remedies for breach are generally governed by proper law, subject to mandatory forum rules. This means that the nature and measure of damages, the availability of restitution, and even equitable remedies like specific performance depend on the proper law provisions. For example, if the proper law in English law damages are calculated by English rule. If it is in French law, then the civil law regime applies. However, the forum, that's the lex fori, ultimately controls enforcement. A forum court will only grant relief permitted by its own procedural rule, e.g., the specific performance, that's the equitable remedy, is within court discretion. In practice, parties know which remedies they can expect by looking at the proper law. If the contract will not be specifically enforceable under the forum law for public policy reasons, that may limit that remedy. The overall principle long recognized in conflict doctrine is that remedies flow from the substantive rights of the contract under the proper law, with only narrow exceptions. So under the legal predicability and efficient dispute resolution, we said a major purpose of naming a proper law is to achieve certainty and efficiency. By predetermining which law governs parties reduces uncertainty and legal costs. We said in international business, the predicability is crucial. Parties know in advance which substantive rules and remedies will apply. This also aids efficient dispute resolution. Court or arbitration can apply the known proper law rather than engage in fact-intensive choice of law investigation or face surprise rules. Ultimately, a clear proper law clause helps avoid lengthy jurisdictional fights and allows tribunal to focus on the merits. That's what we have under the key functions of the proper law.
And that is sufficient. That is sufficient for functions. That is sufficient for functions. Those are the issues that you don't look at any other law other than the proper law of the contract, be it the expressly chosen territorial law or system of law, be it the one that the court will arrive at by implication, and be it the one that will be determined by the rule of the law with the most significant. Yes, good. You have covered functions of proper law. What of limits of proper law? The issues that you cannot ordinarily have recourse to proper law to determine. Did you discuss that?
Yes, we did.
Okay. Let's have your discussion. Let's have your discussion.
Okay, sir. Under the limit, that was the one that my colleague Vincent read out prior to this one, which was where we stated party autonomy and limitation, the closest connection test, and then the jurisdictional complexity and public policy considerations, statutory and constitutional constraints. we discussed that in our 1.4. I don't know if I should go ahead and start discussing them one by one now, sir.
Yes, please.
Okay, we discussed party autonomy and limitations. We stated that the principle of party autonomy permits contracting parties to select the governing laws or their agreement. However, this choice is not unfettered. And we stated that, of course, that we cited the judicial authority, Brunel Logistics, Global, and Eguna, where the court underscored that parties can express their preferred legal framework. Such choices must align with mandatory provisions of the law or public policy. So what we're trying to explain here is that irrespective of the fact that parties have chosen the laws that they want to be governed by, it has to align with the provisions of the law or public policy in the jurisdiction where the case is adjudicated. And then we moved on to discuss the closest connection test as well. And we stated that in situations where the parties have not expressly designated a governing law, courts frequently resort to the closest connection test to ascertain the appropriate legal system for the contract. However, this approach can lead to unpredictability and disparity, as courts may arrive at different conclusions.
Sorry. I've listened to this before. It is not answering the question limit of proper law. If you don't have any other place to point to in your paper, you don't seem to have gotten the issue of limit of proper law. And I can then go ahead to highlight to you what we expected you to do. Can I go ahead?
Yes, sir.
Yes, sir.
Okay. Just like functions, limit is also talking about those questions arising from contractual or supposedly contractual relationship that you cannot apply proper law to govern. Okay? You can divide them into two. Issues challenging whether there is really a contract and issues arising from the contract. So all of the things she listed, which I said was okay, were issues arising from the contract. You want to interpret terms or clause. You want to decide on remedy. You want to say whether the contract has been performed in accordance with the contract. All of these are issues arising from the contract. But there are issues challenging the existence of contract, such as the fact of agreement itself. If the question before the court is to resolve whether or not there was an agreement, if that is the question before the court, it will be absurd for you to say you want to apply the test of the proper law of contract. You cannot apply the test of the proper law of contract to determine whether there is a contract. So if A says there was an acceptance and B says there was no acceptance, how can you say that you want to use the proper law of contract to determine that question? You'll be putting, what do they call it? The horse before you're putting the
cat before the horse.
How do we put it? You'll be putting what?
The cat before the horse.
Yeah, you'll be putting the cat before the horse. There has to be a contract before the proper law can apply. So such questions as the fact of agreement, reality of consent, capacity, formal validity, and some aspect of illegality cannot be determined solely by the proper law of contract. The only aspect of proper law that can apply is what textbook will call putative proper law. In some of the instances, putative proper law will apply. And what do we mean by putative proper law? That is the proper law objectively, only objectively, not subjectively determined. So when you go to any basic text on conflict of laws, okay, they will highlight those issues for which it will be premature for you to be talking about proper law, okay? And I have summed them into 5. The fact of agreement, whether there was offer validly made, whether the offer was validly accepted, okay? Including all of those issues that arise, as for example, where contract was done by correspondence, okay? You know that in some legal system, we will say that the offer was deemed accepted the moment the acceptance letter or the written acceptance was put in the post system. But in some other legal system, no contract is deemed to exist until the letter of acceptance is received. So suppose somebody is accepting through correspondence in a country whose law employs the Torres and Far Eastern Cooperation principle, that the moment you put the letter in the post, there was acceptance. But the other party is going to receive the letter in a place whose own rule says there is no acceptance until the letter is received. How do you, in what way does proper law help in that type of situation? Okay, so those are the type of things we are seeing. Everything will depend on the circumstances of the case. Some of the time, you will be, most of the time, you will be applying what is called putative proper law. And putative proper law means you are assuming that there is a contract, assuming there was even a contract. What is the law that will govern this contract? So, in that sense, express choice counts for nothing, except as one of the factors to be looked at. Implied choice counts for nothing. It is only the law with the most significant contact with the contract that may qualify as the applicable law, okay? The question that the court will be asking itself in that circumstance is objectively determined which would have been the proper law of this contract if there had been no issues with regard to whether there was acceptance or offer. Then we have such other issues as, there are many of them that basic text we discuss. We have such other issues as consideration. You know that the meaning of consideration differ from legal system to legal system. We know the common law legal system, you know their own principle regarding consideration, that the law looks not at adequacy, but sufficiency. The common law position is that consideration must be something of value, okay? And the common law will distinguish between good and valuable consideration. And some of the things like love, affection, friendship, family, etc., they are good consideration, but they do not qualify as the consideration for a contract. But you have other jurisdictions where all considerations are good. All considerations are okay, whether merely good or valuable. So if the two countries connected with the contract belong to the different side of the meaning of constitution. How do you then jump into the position that proper law will govern? There is no contract. If the answer to the question whether there is constitution or not is no, there won't be contract. So to say you are using proper law to determine that is to be jumping the gun. Okay? So what is the law that will govern that issue? Again, the court will say, well, it is going to be the putative proper law. The putative proper law might be the choosing proper law or it might not be. Okay? Then we have such questions as mediation of consent, such issues as mistake, misrepresentation, duress, undue influence. All of these issues we know are issues that are capable of affecting whether the consent that was given, whether the agreement was genuine. And if the agreement was not genuine, then there was no contract. So if the question is, parties were mistaken to each other's intention in making the offer and accepting it, in which case we are saying that the offeree did not accept the offer. He accepted something different because there was a mistake, something like that, or there was a misrepresentation, or there was undue influence or duress. When all these become the issues, when they become the issues, you cannot be saying that the proper law will govern. How can proper law govern? If there is no, if consent is vitiated, there was no contract. And so proper law cannot govern. And some other applicable tests will be considered. But you will find at the end of the day that the court would apply the proper law objectively determined, or what we call putative proper law, to determine that question too. Then we have the question of capacity. Capacity is usually a very long debate. What should govern the capacity of a party to enter into contract? For example, there are countries, or virtually all countries, tend to protect infants by rendering their contract void as against them. But the age of majority is not the same everywhere. You have some countries that age of majority is 21. You have others that age is 18. So suppose a person from a country where age of majority is 19 transacts face-to-face business with another person in a country where age of majority is 21, okay? Should he be able to use his attainment of age of 21 as at the time of contract as a grant to invalidate the contract? That's a question of capacity. So you cannot just jump and say proper law of contract. And so maybe because the contract said the contract will be governed by the law of statewide. And I say, by statewide law, this person has not attained majority. Okay? That question is not a question that proper law can cover. Because if the person has no capacity, there will be no contract in the first instance. So what are the questions? What are the issues? What are the alternative applicable law? Some people suggested that if you apply the place of domicile of the so-called party who is said to be capable. Okay, this is the one that they apply in status contracts, as you will see in cases like Brook and Brook. Okay, we did marriage last time. When we are talking about age as one of the grounds for capacity to marry. So the rule in Brook and Brook says domicile. But should you apply that one in commercial transaction? Should it matter that the person is domiciled in, say, statewide, and under statewide law, he cannot be bound by contract? Should it just be applied, or should we look at other tests? So the textbook will give you an array of other tests that can be applied. Do we apply lex loci contractus? We say, okay, since the contract, especially if it's an executed contract, was done in a particular country, even if that country's law was not the one choosing as governing law, we should just apply the law of that country to determine the question of capacity. That's lex loci contractus. Okay? Do we apply putative proper law? That is the one that would have been the proper law, assuming there was a contract. So all of these tests would arise for competition. And you find that some of the time, the lex loci contractus is also the putative proper law, or that the lex loci contractus is also the law of the place of domicile of the party whose incapacity is being pleaded, and all of that. The textbooks would analyze the cases, and they will not reach any conclusion, but they will invariably talk about putative proper law, either when it coincides with the lex loci contractus. That is the same place that is the putative proper law and is lex loci contractus, or putative proper law as the lex domicili of the parties whose incapacity is being asserted. Okay, so that's the question of capacity. Then we have a question of formal validity. There's a difference between formal validity and essential validity of a contract. Okay? By formal validity, we are looking at those rules that prescribe form, the form for a contract. For example, you know that if you want to enter into a contract relating to land in Nigeria, there must be a note or memorandum in writing. It can't be oral. There are some contracts that they must be under seal, but that is the law of Nigeria. The law of another country might not require them to be so. The law of another country might confer validity on them, notwithstanding that they were made orally. So if A and B belonging to different countries were to enter into a contract in Nigeria, and the contract were to relate to land, okay? If you say proper law will govern the contract, you have put the cart before the horse. Because for there to be a contract, the question of form must first be answered. And so what is the legal system that will answer that question? Okay? Do you apply lex loci contractus? That's law of the place where the contract was entered into. In which case, if the contract was not entered into in Nigeria, our formal validity rules will not be relevant. Okay? But if the contract was negotiated in Nigeria, do we say that notwithstanding the choice, the express choice of the parties of the law of another country, the contract is no contract if it doesn't comply with the form that Nigeria prescribed? That means you're applying the test of lex loci contractus. Okay? Under operative illegality, it is assumed that notwithstanding that the contract is valid under its proper law, if it doesn't comply with the form prescribed by the locus contractus, it will still be illegal. So it means that you are not using proper law tests in that wise. You are using either putative proper law or the law of the place where the contract was negotiated. Okay? Then under operative illegality also, you have public policy. You know that public policy as a rule has nothing to do with the party's choice. It has nothing to do with the party's choice of governing law, but with the party's choice of legislation. So if the party's choice is the territory of statewide, and the remedy, which one of the parties would have got it ordinarily, statewide forbids it, then the public policy of statewide will override, will be cooperate as a factor that can render the contract illegal. That's what we mean by operative illegality. That's what we mean by public policy as operative illegality. Okay, so those are the issues. So those are the issues that we normally discuss under limit of proper law. And what we simply mean by them is that there are questions challenging the existence of a contract itself. And so you cannot say that the proper law of contract will govern them, even though most of the time it is the same proper law that you will apply, either because it would likely be the putative proper law. So that is what we expected you to do. I think the other people touched some of these issues. They were going to discuss it last week when I said their task had finished. Can we look at the last part of their own paper that appears as if they discussed limit of proper law? Otherwise, the presenters of today's paper will have to come back to look at those issues for us. Okay? Any question or comment? Hello?
Sir, is it possible for us to get materials for this topic?
What material do you need? Go and take any basic text. Any basic text on conflict of laws. Okay? Any basic complete text. If you can lay your hand on Okoli and Opong, or you look at Morris, okay? They will discuss all of these issues, and you will be home and dry.
Okay, sir. Thank you very much, sir.
So let us take contract as concluded. Let's take, who is ready? Is it trust or corporation? are supposed to finish all the topics on law today, but as way to have it, I overslept. Which is ready, trust or cooperation? Let's take one of them so that we can take the other one next week. Hello?
Yes, Prof. Hello, sir.
Yes. The group is sending trust. They can finish that one in 30 minutes now. Trust in the conflict of laws.
That's group 4, sir. Please, members of group 2, please.
Trust is group 5,
Okay.
sir.
Okay, group 5, please.
Okay, group 4 is corporations, isn't it?
Yes, sir.
Okay, are they ready?
Good evening, Prof.
Yeah, good evening.
Sir, we are not ready. Sir, we are not ready. One of us is not feeling too well.
Is that the group whose leader complained to me in the day that his members are
Yes, sir.
not cooperating?
Yes, one of us is not
I
feeling
think
too
what
well,
we
sir.
should do is to non-suit you. You people are not serious. You have not even submitted anything. From what you told me in the afternoon, you are yet to submit.
We
So
apologize.
are we going to be waiting for you? I mean, I don't think I have that time. Oh. I don't think
Sir,
I
if you
have
can
that
give
time.
us up to next week, we'll be ready, sir. We are already working on the part. The person who is not feeling fine. We are doing her part already.
So the next, hello, the trust people, can we trust you?
Yes, sir.
Okay. Summarize your paper in a few minutes. You know what we want you to talk about now. You know what a trust is. You know
Yes,
you can everything relating to creation of trust, trustees' duties, trustees' obligation, remedies, etc., can be local in the sense
Yes,
that everything begins and ends in one country. But you can also have a situation where trust property covers several territories. You can have a situation where beneficiaries are not living in just one country. You can have a situation where do not or the person creating the trust is in one country, the properties are scattered across the world, the beneficiaries are also scattered across the world. So you will see that in that circumstance, there is a foreign element. So the conflict of law issues arising from that situation and the governing law is what we want you to discuss. Are you ready for us?
Yes, sir. But I would like to bring it to your notice that there are only 2 that worked on this paper, sir.
Did you put the name of the 2 there? Don't put the name of a person who didn't participate.
Yes, sir. Yes, sir.
So the status of that person as a member of this class is doubtful. The person has lost some good 20 marks because the 20 marks is what we use as CA. So it is very simple. If you belong to a group where some people are not cooperating, to save yourself, just go ahead and present something. Write and present something. We will never include somebody who did not participate in the writing of seminar paper in the 20 mark CA. The person can then decide whether he is brilliant enough to make good grades without 20 marks. It's as simple as that.
Yes, sir.
So that's not an excuse. You are ready to present, isn't it?
Yes, I am.
Okay, go ahead and present the paper. They name the two people who wrote the paper and who are ready to present it. Let class governor take note of it.
Okay, myself, I am Alagwa Esther, and the other person is Sebastian Alexander.
Okay. So only two people wrote and presented the seminar paper on trust.
Yes,
I
sir.
don't want to see anybody be included for purpose of CA when it is time to assess. So go ahead.
Okay, sir. So I'll be taking the first part of the paper, then my colleague will take the second and the third part. So, and I'll start with concept and classification of trust. I classify trust as an express trust, implied trust, and fixed and discretionary trust, bare trust. Then the legal nature of trust. I looked at ownership, control, and equity. In a trust, the trustee holds legal title and controls the property, but the beneficiary owns the benefit. So that is the equitable interest. So um, the trustee has a fiduciary duty and must act in good faith, but the beneficiary's interest must come first, and it must follow the terms of the trust. So if a trustee abuses his role, the court can step in, as we all know, and provide remedies. So I will move further from that introduction to 1.4, recognition of trust in mixed jurisdiction like Nigeria. So Nigeria has mixed legal system. You have the common law, customary law, Islamic law. They all operate side by side. So English trust principles are part of Nigerian law, and trusts are formally recognized under statutes like Trustee Law, Trustee Investment Act, and CAMA. But in practice, not all arrangements labeled as trust follow strict legal rules. For example, in customary law, things like family land stewardship may look like a trust, but they don't always meet the formal requirements like certainty of intention or defined beneficiaries. So, in the case of Shell, BP, Petroleum, and Abedi, the Supreme Court accepted that customary trust can exist, but only if they show clear fiduciary intent and meet the basic element of trust. In the North, Islamic law introduces similar institutions like WAQF, WAQF, a religious endowment, which function like trust, but are governed by faith and not equity. Internationally, Nigeria isn't part of the Hague Trust Convention. So when it comes to recognizing foreign trust, the court falls back on the general conflict of law principles like party autonomy and proper law. So, and when I say party autonomy, what do I mean? It simply means that the people creating a trust, usually the state law, they have the freedom to choose which country's law will govern the trust, as long as the choice of law, the governing law is clear and it is not against public policy, the court will respect it. So, for example, uh, if the trust property is in Nigeria, the state law can say the English law should apply, and Nigerian courts will usually honor that, unless it can cause serious legal conflict. I will touch a little bit of part two before my colleague takes over. 2.1, the connecting factors in private international law. So when a trust involves more than one country, the court relies on what we call the connecting factor to that.
Go on.
Okay, sir. So the court relies on the connecting factor to decide which law will apply. So, and some of the factors the court will consider will be one, the settlor's domicile, the place of administration, the location of the trust property, the express choice of law, and the place where the trust was created. So these are the factors that the court will consider. They'll look into them to find the law with the closest and the most real connection to the trust. and you can see the case of McDonald's and McDonald's. So my colleague will continue from 2.2, determination of the applicable law of trust or the proper law of trust.
We are waiting now. Hello?
Hello, sir. It seems it's not, I think
Hello.
maybe.
Good evening, Prof. Sorry, my
Yeah,
network was cracking, so I couldn't hear. So from part 2, we spoke about the connecting factors where we underlined. We also spoke about the lex loci administrationis, the lex domicile, where we stated that the selector's domicile is a significant factor, particularly where the trust is inter vivos. Court often looks to the habitual residence or domicile of the selector at the time of creating the trust as an indicator of intention. We also looked at the lex loci administrationis, that's the law of the place of administration of the trust, where we stated that the location where the trust is administered can serve as an important connecting factor. This includes where the trustees are located, where the trust bank accounts are held, and where decisions relating to the trust properties are made. We also look at the licitus, that's the law of the place of trust, the location of the trust property, especially immovable properties, often determine the applicable law. We also look at the governing law expressly chosen by the selectors, that's the law expressly chosen by the parties. We also looked at the law of the place where the trust is created, the place of execution of the trust deed, or the law under which the trust is incorporated may also influence the applicable law. Determination of applicable law of trust. We made comments as to the express choice of law, that is the considerations that the court will put in place in determining the proper law. We looked at the express choice of law and the implied objective determination. That is, the express choice is where parties have agreed as to the particular law that would govern the trust. And implied is whereby the court would infer from the transaction and from the intentions of the party what law would apply. Hence, that the parties did not indicate any applicable law. We also looked at parties' autonomy and role of default rules. That means that the supremacy of contract, that the parties have a right to determine what law would govern in a trust agreement. We looked at the case of Bank of Africa Limited versus Ogunbayi. We also spoke about the Hague
What happened in
Convention.
that case? What happened in that case? You didn't look at the facts.
No, sir, but we expressly stated that the Nigerian courts recognize the importance of respecting contractual autonomy in that case.
Okay. Go on.
We proceeded with the Hague Convention on law applicable to trust and on their recognition, where we stated the key provisions of the convention.
Did you first noted that Nigeria is not part of that convention?
Yes, sir.
Nigeria is not even a member of the Hague Conference on Private International Law anyway.
Yes, sir.
Private international law is the most neglected aspect of our treaty activity in this country. Go on.
Thank you, sir. So we looked at key provisions in that convention, where we looked at Article 6, affirming the selector's right to choose the governing law. We looked at Article 7, provides fallback criteria for determining applicable law based on the closest connection. We looked at Article 8, outlining the matters governed by the proper law, which include validity, construction, and administration. We also looked at Article 11, mandates the recognition of a trust that is valid under its applicable law. We also look at Article 13, allows a forum to refuse recognition if it's manifestly contrary to public policy. So we now considered public policy and forum restriction, where we stated that public policy, Nigerian courts may refuse to enforce a foreign trust where it offends local policy or mandatory rules. For example, a trust that contravenes inheritance law or tax recognition may be deemed unenforceable. We looked at forum restriction. Courts may decline jurisdiction over immovable properties located in another state, applying the lex situs rule, where we considered the case of Ojukwu versus military government of Lagos, where the Supreme Court reiterated the importance of lex situs in determining rights over property. Let me move forward. So we also considered comparative analysis of trust in conflict of law, and we looked at the Nigerian approach, where we said the Nigerian approach to conflict of law in relation to trust reflects its colonial legal heritage and its involving engagement with transactional legal interaction. So this part of our paper was prepared by my colleague. I don't know if my colleague would have to make comments to it.
Okay. Let your colleague make the comment.
Definitely based on English common law. There is no Nigerian law of punishment. So Nigeria can fall back on general private national law. And so the court usually applies the proper law of trust. That is the law.
I can't hear you again. No.
Hello, sir.
I don't know whether others are hearing you, but
Hello, sir. Can you hear me?
I can hear you now.
Okay, sir. Thank you, sir. So I said that the courts usually apply the proper law of trust. That is the law chosen by the set law. So if there is no law chosen as the governing law, then the court will consider things like where the trust was created and where the property is located, or where the trustee or set law resides. For example, if a trust is created in Lagos, but the assets and trustees are in England, the court may decide that the English law will apply. So although Nigeria isn't a signatory to the Hague Trust Convention, our court sometimes recognizes foreign trusts so long as they don't violate Nigerian public policy. Then in the case of the estate of Alhaji Ganiyu Aremi Shitu, a UK trust was accepted in Nigeria because it complied with common law principles and didn't break any Nigerian law. So, but Nigerian courts will not enforce a foreign trust if it clashes with public policy, as I said. For example, a trust that discriminates based on gender in inheritance may be struck down because it violates Section 42 of our 1999 Constitution, which forbids discrimination. So, customary law, it also plays a role. The case of Agbaje and Agbaje, where a Yoruba family land agreement was treated as having fiduciary duty and was also treated as similar to a trust, even though it was not called a trust. So I'll give an example. For instance, where a Yoruba family appoints the eldest son to manage ancestral land on behalf of the others, though it wasn't called a trust, but the court would treat such as a trust. So where a Nigerian person sets up a trust in South Africa and the trust property and the trust owns property both in Nigeria and South Africa, if there's a dispute, a Nigerian court will have to first decide whether they should recognize South African law, and if yes, um, then does the law does not contradict, is not contrary to public policy. Then, if it is not, then it is the proper governing law be applied in such. Then 3.2, England's legal framework and recognition of Trust Act 1987. So I started by saying that England is has over the years built a solid and sophisticated legal system around the concept of trust, especially when it comes to handling both local and international trust matters. So England passed the Recognition of Trust Act in 1987, which brought the Hague Trust Convention into English law. And that act now plays a role in how England recognizes and enforces foreign trust. So under Section 1, subsection 1 of the Act, the courts are required to recognize any trust that is valid under its proper law. So whether or not it's governed by English law. So if a trust is valid where it is created, then the English court will generally accept it. Also, the settlor can choose which law governs the trust, and where no choice is made, the court considers factors like where the trust is managed or where the assets are. For example, if a trust is set up in Switzerland, but states but the trust states that English law should apply, the English court will accept that, even if the trust assets are abroad. Then also the English um, this act recognizes some types of foreign trusts that are unfamiliar to terms like purpose trust, and provided that they meet the basic requirements. I cited the case of Duke of Marlborough settlement, where the court upheld that a foreign trust based on the settlor's chosen law is valid. However, public policy still matters a lot. So English court can refuse to recognize any trust that is unlawful, discriminatory, or used to avoid creditors. Then also, another point is if the trust property is located in England, then English court will likely take jurisdiction, especially over land, and will apply the lex titles rule. Because, okay, I think that's all. I will move to choice of law and titles. In England, party autonomy is respected. So if the state law chooses a particular state law, for instance, Delaware, courts will usually uphold that choice of law. That yes, will uphold that choice, especially if there is a link to that state. For example, if a state law living in California chooses Delaware law because Delaware offers stronger asset protection, especially if the trustee or assets are located there. The court will uphold such. If the trust does not specify a law, courts apply the law of the state most connected to the trust. This includes looking at where the trustee is, like I said, where the asset is, where the trust is being managed. The case of in the pure trust case that was mentioned. So recognition of foreign trust. USA. The US is not a signatory to the Hague Trust Convention, but courts still recognize foreign trust as long as they don't break public policy. The case of Caterpillar Incorporated and Usino Industrial, where the US court enforced a foreign trust in a business dispute, showing that foreign trust can be recognized even in commercial context. So I looked at public policy and constitutional limits. Still under US courts can refuse to enforce any trust that violates public policy or constitutional rights. For example, a trust that discriminates based on race or religion can be struck down under civil rights law or the Equal Protection Clause, as seen in the case of Safaria and Union National Bank. We also looked at offshore and digital trust, and these are new issues emerging under trust. The IRS has started tracking on foreign trusts that involve crypto or online platforms and raises question about enforcement, taxation, and jurisdiction. In short, the US system relies heavily on the state law, and judicial flexibility. Even without federal uniformity, courts have developed a fairly practical way to handle cross-border trust issues. So the other comparative analysis I did in 3.4, we looked at France. But before that, we talked about civil law countries in comparison with the common law legal system. He said civil law doesn't split ownership into legal and equitable parts. So trusts have always been a bit foreign to them. But due to global commerce, many of these countries have found ways to mimic trust structures. And we looked at France, for example, introduced the fiduciary in 2007, and it's similar to trust. A person gives assets to a fiduciary to hold for the purpose of for a third party, but it's heavily regulated and it's purely contractual. So there's no true split in ownership. There's no true split in ownership like we see in common law. In Germany does not recognize trust. Their law insists on unified concept of ownership. And in Japan, they adopted trust law way back in 1922, influenced by English and US models. And then by 2007, they modernized it for commercial use. So Japanese trust now follows the dual ownership structure, and their courts can recognize foreign trust if they meet the legal criteria. In China introduced trust law in 2001, mostly for commercial use, but the model is more controlled. It does not fully embrace settlers' autonomy, and trusts are treated like contract or fiduciary arrangement, not full-on equitable trust. So also,
Okay.
okay, sir.
We are listening to you. We are listening to you. We discussed your paper next week.
Okay, sir.
We discussed your paper next week, but let me say one thing that I like about your presentation is your comparison.
Okay, sir.
Okay?
Thank you, sir.
And we are seeing, especially in all the countries where the concept of trust is recognized, we have seen a common trend. The trend of internationalism or committee, that you do not see as a general rule that you will not accept, you will not recognize a trust because it is not governed by your country's law, or the law with which it is governed is different from your country. We have seen that in that wise, trust is almost the same as contract. The same basis of determining governing law of a contract, which is express, implied, or the law with the most significant connection are virtually the same basis of determining governing law of a trust. It is under the law with the most significant connection that all of those other factors, like where the trust was created, where the property is located, where the with trust, the beneficiaries are located, the center of administration, the bank holding the trust money, and all of that, all of those issues, they become the different contacts that a court would consider in arriving at the governing law of a trust if there is no express or implied choice. And we can see that even though there is a Hague Convention, there is no fundamental difference between the countries of the world in the treatment of cross-border trust. That is, the countries of even the countries that are not member of the convention, and so well, that's what you can get from your presentation. I have not read your presentation. I will try to look at it, and in 10-15 minutes, talk to it before we move to another topic. If the people doing company are not ready, we will non-suit them, and I will discuss the topic in class, and that will be the end of the law topics. We can then move to jurisdiction. So I see you people next week.
Okay, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir. Good night, sir.
Tí wọn rọ́kùnrin mi jó kírun fún wa ni. Ẹ́ náà wo ni òun lọ tó kú sẹ́wọ̀n láàárọ̀. Wọ́n sọ fún méjì kó lọ wò lánàá, ó ti rárá gbọ́, kò dá mi lóhùn. Anyway, mo ti sẹ́ni owó sí ní ìbámu bóyá ó ti dàbọ̀ kò tilẹ̀. Only 62,000, nothing more. No, many don't send them more can read me. Me wo. Mo kàn fún mi ní alert 62,000. The message me say WhatsApp go tell you. No, wo. Mo wà lecture náà ṣe bí ààrẹ nígbà tí mo ṣe lecture lọ́wọ́ ló sẹ́ni. Ọlọ́run ni ó ti àdúrà ẹ̀. You are becoming very hard. Ẹ ṣé o, mo dúpẹ́ lọ́wọ́ yín o. Bí ti dá sẹ́yìn fẹ́ kí n ṣe náà nìyẹn. Kí ni tọ̀ yìí ń pè mí?
àárín yín o mo ní àárín yín o àwa ń gbọ́ yín àárín yín ni Mr. Monday mo ń gbọ́ yín hello sir à ń gbọ́ yín o ok ó ti ń gbọ́ àwọn èmi ti mọ̀ ẹ́ náà tẹ́lẹ̀ omi ìdè máa ń gbé machine ìgbà ló máa bá mi gbé it not á lọ sí ní lọ
Ṣé ọ̀gbẹ́ni tó sọ pé òun ti nǹkan òun ti dé láti yà?
hello sir àwa ń gbọ́ yín o ẹ̀yin ìdá báyìí. kí lẹ̀ ń wá káàkiri kí lẹ̀ ń wá kiri ìlú. mo ti gbọ́ all right. mo fẹ́ kò náà déhùn ìyẹn náà ní problem tó ń.
Engineer Adekunle ò mà sí around. Ó ti mo ti sẹ́ndì láti 11 o'clock. Wọ́n á ti ṣe kí ni? Wọ́n bá ti ṣe mi ò ní pè wọ́n náà. Ibẹ̀ náà mo ti ń kọ̀ ní.
time ìta ní ṣiṣẹ́ ti short. Òun láì fi dé parí 72 hours. That a lè achieve ọ̀pọ̀ mú. Nítorí pọ́nà ń gbọ́n jù wà lọ, náà jẹ́ ká pé pé 24 hours nínú ojúmọ́ kan.
Irú rẹ̀ yìí. Irú tiẹ̀ yìí.
Ó ní because ọlọ́run mọ̀ pé brain wa náà ó ní láti tó bá ti bẹ̀rẹ̀ tábà kan ṣiṣẹ́ lọ táǹtì ìpele máa pọ̀ jù kì. Táàgbà ẹ̀ ó jẹ́ pé working hour náà ó ní iye time àdẹ̀gbọ́dọ̀ padà sílé lọ́sùn. Ní time báyìí. Òun mọ̀ bọ̀ òun ní ìka àṣìwò gbọ́ngàn torí alẹ́ lòun máa ń lọ títì òun máa pàdé sówó owó dẹ́ta yẹn jẹ́ ká ṣiṣẹ́ púpọ̀. Wọ́n á ní kò sí báyìí fẹ́ ṣiṣẹ́ tó. One day we all need this work. Office work will not complete it. There will always be something every day. The other day we will pay. Bẹ́ẹ̀ máa gbọ́. Ó paná. Ó jẹ́ kó ìdáìmì ẹ̀ náà. Ó lọ fẹ́fẹ́. Àwọn tó bá pẹ́ ìdíjọ́. Ó ní òun 9 o'clock òun ní dínà pẹ̀lú wọn. Ọba bá àwọn fún ìdílé kó tó kúrò. Ní àkọlọ́lé tó bá lọ ní àlọ́ tìǹì. Á sinmi tán. Á dẹ̀ refresh á freshen up á dẹ̀. Fún sinmi síbí wo pẹ̀lú àdúgbò iṣẹ́ tó wà nílẹ̀.
Ẹ máa ṣe sà. Ẹ bá mi lù sà. Ẹ bá ṣe lọ sà.
Ìyá lọ parí.
Èmi ọlọ́pàá náà ní wò.
Iná ọ́fíìsì láti ní sọ òfin náà nù. Ọlọ́dẹ ṣe òfin náà ní pé jẹnẹrétọ̀ ní problem tó ń lọ tó ń bọ̀. Ìyá parí. Ìwà kó bá mi.
Tó bá mọ̀ pé ọlọ́pàá mi.
Ẹ̀mọ̀ pé pàṣẹ tó bá ń tọ́jú náà wò kí n change ìmọ̀ change. Change over ni mò ń sọ.
Wá ní kẹ́ máa lọ.
Àgbẹ̀tọ́ ní nígbà wá ti fún wa ní space pé kóun plant sí àyè ẹ̀. Tó bá bọ́ sà ó lọ fáàmù. Èmi àti ìdègbé báàgì. Bọ́sà. Owó fi jẹ́ kí n já ewé ra nìkan.
Ó mọ̀ pé ìyàwó ní.
Wọ́n yóò ní bígáàdì fún gbogbo yẹ òkú gan o. Bá a fẹ́ máa kúrò di 12 o'clock wà láì kò ní sọ pé nù. Pé kí n máa wà ń bẹ̀rẹ̀ di 12 alẹ́ kò ní sọ pé nù. Ní ìròyìn yàn. Ó máa ń rò pọ́kùnrin ní mí ni. Àdúnnù òkú. Dada ló máa ṣe yàrá kàtó yàrá. Yes. Salam alaikum. Jálọ. Kí ló ń ṣe jálọ? Ẹgbẹ́ yẹn ò lówó tẹ fẹ́ fún wọn. Wọ́n jẹ́ confirm.
Confirm.
Iná máa pọ̀ nà.
Gbogbo ẹ̀mú ti ṣe.
Ọ̀tẹ́lẹ́pẹ́ ń pe WhatsApp kò lè fún jẹ́.
Iná máa pọ̀. right food. Wọ́n bá àti màá ní o. Dẹ̀kí ń ṣe òní ni mo mọ àwọn àgúnmu yín náà. Ah, kéèjì bíbò tí ọ̀gbẹ́ni yóò bá ti tan iná ẹ̀ ní tan gbogbo àwọn fírísà yín ni. Ó sì kú 7 units. Nígbà tá a ti wá pé tí ò gbé fóònù nǹkan. So online 726. Wọ́n pè mí nígbà tí mo wà kíláàsì nírọ̀lẹ́.